on hits, on territories, on dealers, and I think this is a very serious thing. I've introduced legislation that would make cell phones contraband in federal prisons, with possession punishable by up to an additional year in prison. What do you think of this? What are you doing? It is a real problem, Mr. Attorney General.
No, it is a real problem, Senator. I had experience with that when I was the United States Attorney here in Washington, D.C. Rayful Edmond, who was a very notorious and large drug dealer in Washington, D.C., was convicted, sent to jail, and then continued to run his drug enterprise from prison, was convicted again for that. The maintenance of cell phones in prison, I think, is unacceptable, and I think we have to find ways in which we confiscate them. I think you're right. They ought to be considered contraband, and I think we ought to also look at what technological means we have that might possibly block the use of cell phones in prison for those that, for whatever reason, we are unable to get from prisoners.
Would you take a look at my legislation, and
Yes.
Your support would be appreciated?
I certainly will do that.
Thank you.
I think the idea that you have, though, and the concern that you have is a very legitimate one, and one that we have to deal with.
Thank you. In June of '09, the GAO released a report indicating that individuals on terrorist watch lists succeeded in purchasing guns an astonishing 865 times between 2004 and 2009. This dangerous loophole in federal law is known as the terror gap, and it's continued to allow the individuals on the FBI's terrorist watch list to purchase guns, despite the fact they're not allowed to fly on an airplane. The Bush administration's Justice Department drafted and supported federal legislation to close this gap in the 110th Congress, and identical legislation has been introduced in the 111th Congress. Does the Justice Department support closing this gap, and will you support that legislation?
Yes, we will support that legislation. It seems incongruous to me that we would bar certain people from flying on airplanes because they are on the terrorist watch list, and yet would still allow them to possess weapons. I think that the legislation that was initially proposed by the Bush administration was well conceived, and we will continue to support that.
Excellent. Thank you very much, General. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. And Senator Grassley.
I have an observation and a couple of questions. My observation that I don't want you to respond to is, I don't know how you can make a statement that failure to convict is not an option when you got juries in this country. I think a lot of Americans thought O.J. Simpson ought to be convicted of murder rather than being in jail for what he's in jail for now. It seemed to me ludicrous. You know, I'm a farmer, not a lawyer, but I just want to make that observation. Question. You previously pledged.
I think it's only fair you ought to be able to respond to that.
Okay, as long as it doesn't come out of my time.
Well, that's fine. And maybe I should have been more, expansive in my response to the question that Senator Cole put to me. I mean, certainly I have thought about, you know, that possibility. And one of the things that this administration has consistently said, in fact, Congress has passed legislation that would not allow for the release into this country of anybody who was deemed dangerous. And so that if there were the possibility that a trial was not successful, that would not mean that that person would be released into our country. That is not a possibility. But again, I want to emphasize that I am confident that we will be successful in the trial of these matters.
Yeah, and it's my understanding that if he's not convicted and somehow the judge lets him off on a technicality or something, then he becomes an enemy combatant, and you're right back where you started. So what do you gain? But anyway, you understand the law. I don't. I'm just trying to bring a little common sense to this. You previously pledged to respond, quote, fully and in a timely fashion to Judiciary Committee inquiries. Senator Leahy and I wrote you in October with a list of outstanding unanswered requests. I do appreciate your courtesy reply and your willingness to have your staff meet with mine to work out this backlog of requests, but I am disappointed that your reply to Chairman Leahy and me indicates that you are considering not answering pre-2009 committee questions to the department. This position is completely unacceptable to me. These unanswered questions deal with serious matters such as national security, whistleblower, law enforcement. Are you you're not upholding your pledge to respond to all outstanding requests that as you told me you would when you came to my office prior to confirmation? I even tried to help you by giving you a big, thick file of things that were unanswered from the previous administration. I wanted to save you any embarrassment. I wanted to save President Obama any embarrassment for what the previous administration didn't do right in responding to proper requests. So why are you and the department not willing to answer these questions?
Well, what we've tried to do is certainly answer all of those questions that have been propounded to us, that propounded to this administration, and I think we're up to date in that regard. I do remember that booklet that you gave me, and I think that we have done a pretty good job in responding to those. I know our staffs are meeting, I believe, on Monday or Tuesday of next week to try to discuss this. It is our hope that we can find a way to stay current with the questions that are given to us and also deal with the backlog that you are discussing. It is not a question of us not trying to do that. We really were trying just to prioritize the way in which we respond to these questions. And I hope our staffs will be able to work together and find a way through this.
Well, Senator Lays has committed to me that he'll work with me to get that job done, and thank you very much, and I hope we'll be successful. On Guantanamo, the decisions to bring detainees to the United States and afford them civilian trials is highly questionable. I want to know more about who is advising you on these decisions. There are attorneys at the Justice Department working on this issue who either represented Guantanamo detainees or worked for groups who advocated for them. This prior representation, I think, creates a conflict of interest problems for these individuals. For instance, Principal Deputy Solicitor General Neil Katyal represented Osama bin Laden's driver and bodyguard in his case challenging the earlier versions of Military Commission Act that Congress passed on a bipartisan basis. I'm quoting National Journal. Mr. Katyal has not recused himself and is still working on detainee matters at the Justice Department. The article indicates that other attorneys with previous involvement of detainee issues are also on detainee issues at the department. Another example, New York Post reported that your department hired Jennifer Daskal to serve in a national security division. She also serves on a task force deciding the future of terrorist detainees. According to the article, Ms. Daskal has no national security experience and no prosecutorial experience. She has, however, a background of advocating for detainees. One example of her advocacy is from a 54-page report that criticized Guantanamo Bay's treatment of the terrorist detainees, where she stated one detainee described as a self-styled poet, quote, found it was nearly impossible to write poetry anymore because the prison guards would only allow him to keep a pen or pencil in his cell for short periods of time. As a consequence of these three examples, I want to know more about these potential conflicts. Would you provide me and members of the committee with the following information? The names of political appointees in your department who represent detainees who work for organizations advocating on their behalf, the cases or projects that these appointees worked with respect to detainee prior to joining the Justice Department, and the cases or projects relating to detainees that have worked on since joining the Justice Department. Would you please provide that information to me and the committee?
Okay, I will certainly consider that request, but I want to make sure that you understand that the people in the department understand their ethical obligations, and to the extent that recusals are appropriate on the basis of prior representations or prior connections, people in the department have recused themselves from specific cases. I have been recused from a couple of the habeas cases that are pending here in the District Court of the District of Columbia because my firm, not because I did, but because my firm represented or had some connection to the person who was the subject of that habeas proceeding. So we're very sensitive to that concern and are mindful of it, and people who should not be participating in certain decisions do not do so.
But I ask you for information. Will you provide it?
I will consider that request.
Well, I'm not. Well, let me tell you then, I think your department probably is doing what's usual, but let me quote law professor, Dean of Law College of Law, Don Burnett. What's unusual is the size of the cluster of the individuals who are affected. And so, you've got a big job ahead of you that you've taken on, moving this stuff from military commission. It seems to me we need to know who's involved in it and what their predilections are. I yield back.
Well, let me say this about the people who work in the Justice Department and who work on these cases. They are fine public servants who have sacrificed a great deal to work in the department. They apply the law as best they can. They are patriots. They are concerned about the security of the American people. And whatever their previous roles, I'm confident that they can put those aside or recuse themselves. And I'm confident that the people who I am speaking with and relying on have the best interests of the American people, including the national security, uppermost in their minds.
The very least you can give me is a list of the recusals.
And as I said, I will consider that.
Senator Feingold.
Hey, Mr. Chairman, General, I want to commend you for your decision to try Khalid Sheikh Mohammed and other 9/11 plotters in federal court. It's about time that we bring these criminals to justice, and your decision shows the world that this country stands firmly behind its legal system and the Constitution. As you know, I don't agree with every decision you've made in this area. I remain skeptical about the decision to try 5 other Guantanamo detainees in military commissions. But too much of the criticism directed at using our federal courts has not been based in fact. Some conservative commentators have gone so far as to call it scaremongering, and they have called for it to stop. More than 200 terrorism defendants have been prosecuted in our federal court system since 9/11, and federal prisons securely hold more than 300 inmates whose cases were terrorism-related. Zacarias Moussaoui was successfully prosecuted and convicted in federal court of conspiring with al-Qaeda on the 9/11 attacks and is serving a life sentence. And yet I don't remember hearing the kind of uproar about the decision to try Moussaoui in federal court that we're hearing now. So it's a little disheartening that critics of your decision seem to have so little faith in our system of justice. So, Mr. Attorney General, how does your decision to seek justice in federal court support our fight against terrorism?
Well, I think that I have great faith in our system. And it's not a speculative faith. It's based on experience. The cases that you mentioned, the familiarity I have from the federal courts, having been a prosecutor in those courts, gives me the belief that we're going to have an ability to maintain courtrooms in a way that is consistent with what I think we want. There'll be a level of decorum. I think that we will have an ability to introduce the evidence that we seek to introduce. And that our courts are capable of handling this whole concern that people have expressed about the dispersal of classified information. We have done it in the past, and I'm confident that we can do it with regard to these 5 individuals.
And I've been raising concerns for a while now about the possibility of establishing a so-called indefinite detention regime. And recently, a statement rejecting indefinite detention without charge was issued by more than 130 former members of Congress, diplomats, federal judges, prosecutors, high-level military officers, and national security experts representing the full political spectrum. The declaration said this: instituting a system of indefinite detention without charge in the United States for terrorism suspects would threaten the constitutional protections enshrined in our justice system and is simply bad policy. General, can you tell us yet whether there will be any Guantanamo detainees who will be neither prosecuted nor transferred to another country, and is the administration currently contemplating holding some detainees without trial for an indefinite period of time?
the possibility exists that at the conclusion of our review with regard to the detainees, the people who are held at Guantanamo, that there will be a number of people who we will seek to detain under the laws of war. We will do so in a way that is consistent with due process to make sure that those determinations are made in a way, as I said,